to everyone.
That wouldn't be a proceeding brought under this part, such part.
I think, other than with respect to an individual against whom proceedings have been initiated, refers to removal proceedings. That's my understanding of what that term means. And then there's obviously a number of massive. So I would argue the harm that we're talking about, the $3.5 billion for the April crowd and about $8 billion for everyone, that's triggered totally aside from whether or not people are put into removal proceedings. But the reason I raise this is to say that it doesn't make any sense that a provision like this, with an exception clause like that, would apply to this sort of programmatic policy where you're going to strip all these people of their employment authorization well in advance. But even if you reject our view, you'd have to split with the Fifth Circuit and all these district courts, and you'd have to explain why this is consistent with APA doctrine, which they still haven't done. All they've said is they think all the APA doctrine is wrong. But even if you went that road, we wouldn't be done. We would then, we'd come back here and say, there's thousands of people who, even under their interpretation, are entitled to relief and could be getting relief in this action. In this case, it doesn't say that you have to bring it in removal proceedings. It just says that you can't grant an injunction other than with respect to an individual against whom proceedings have been initiated. So, it's just all to say, like, they point to this as though it's a solution to the problem, but it just opens its own massive can of worms.
Well, I'm not sure they're saying a solution. They're saying it informs the interpretation of the rest of the statute. Well, you've got a savings clause that's been delimited, and therefore that would, I guess, argue for a broader interpretation of the front end of the statute.
I see. So then my answer to that would be the point I just made a minute ago, which is that there's a huge amount of harm caused by the termination, which cannot be addressed by waiting to raise challenges in removal proceedings. So it doesn't argue for a narrow interpretation on that basis. And the other thing I would say, Your Honor, is, as I understand it, their position is that the illegality of TPS, of the TPS termination and vacatur, cannot be raised in removal proceedings. That was their position last time, anyway, in Ramos, that we couldn't litigate these questions we're litigating now. Of course, the individual in removal proceedings couldn't compel the production of the administrative record, what we started the hearing with. So for both of those reasons, I would argue that the existence of the savings clause cannot be sufficient to resolve the problems that would be created by stripping.
In other words, there's no other forum to litigate this. It would preclude entirely judicial review, hence the rule of construction about narrow construction of such.
Yes, Your Honor.
Prohibitions.
Yes.
All right, we got to move on. Thank you to the other jurisdictional question, and whether that means judicial review, which is barred with respect to, quote, any determination with respect to the designation or termination or existence or extension of a designation of a foreign state. We did look at this question, and so did the Ninth Circuit panel in the now vacated Ramos decision in the Ninth Circuit. But the vacated decision, even the majority there, reached conclusion that the sweep of 1254B5 is limited, that determination, which is a key term here, pertains to review of the underlying considerations and reasoning employed by the Secretary in reaching her country-specific TPS determinations, determining whether or not conditions are so adverse that it's dangerous to send people back. Those are the kinds of things that are generally not reviewable, but that sort of procedural or collateral matters can be, and even under that framework, which is not binding here because that decision was vacated, but it's an indication of at least how three judges look at it. You look at such factors under McNeary, as I understand it, as cited by the vacated Ramos decision. Is the review based on the merits of the individual situation, or is it a broad challenge? Is the administrative record for a single decision, does that have any relevance? Is that needed in the determination? And is the examination peculiarly within the agency's special expertise or integral part of its institutional competence? I mean, those are some factors that you looked at.